Lyft and Uber and their drivers, pay attention to a U.S. Supreme Court case holding that an interstate truck driver does not have to arbitrate his wage and hour claim even though he signed an arbitration agreement. So the court says the Federal Arbitration Act requires federal courts to enforce arbitration agreements. But there's a big exception. You can drive a truck through this one for contracts of employment of any class of workers engaged in interstate commerce. This truck driver, listed as an independent contractor, but the court says he has a contract of employment because back in 1925, when the Federal Arbitration Act was enacted, folks didn't make a fine line between what's technically an employee and what's technically an independent contractor. They're all workers. So now the big question, is an Uber driver in interstate commerce? If so, the Federal Arbitration Act does not apply, and federal courts won't push their wage and hour claims into arbitration. Be interesting to see what the lower courts do with this. I'll see you next week.